Good morning, everyone, and thanks for joining us here at Forbes. I'm Georgina Kenny. I head up the property litigation team here, and I'm just going to go through a few slides this morning to give you a bit more information on the Renters' Rights Bill and what it means for you as managing agents and estate agents for your landlord clients. So, it's been a long time coming, but the Renters' Rights Bill is likely to come into effect in late 2025 or early next year. Currently, the Section 21 no-fault evictions are due to be abolished, and all fixed-term ASTs will become periodic. So a big impact really there in respect of the tenancy agreements that are in play at the moment. The Renters' Rights Bill is the most significant reform in the private rental sector since the Housing Act in 1988. So it has been a long time coming, albeit it's taken a long time getting it through Parliament. So it was actually first introduced into Parliament on the 11th of September 2024. And the bill has, as you know, wide-ranging implications for landlords, tenants, and letting agents alike. Lots of reforms are proposed to basically protect tenants. Arguably, the private rental sector is going to be most impacted by these changes, in particular private landlords. As the bill is expected to become effective in a matter of months, letting agents, estate agents, managing agents, whatever we want to call ourselves, need to know everything about what's in store so you can be compliant and ensure all sorts of compliance for your landlords. While there will be challenges, there's also a lot of opportunities to take advantage of. In these slides, we'll cover just a few of the key talking points while signposting you to the resources where you can learn a little bit more. So, when first introduced, the Renters' Rights Bill, which was initially called the Renters' Reform Bill, was seen to be part of the UK government's agenda to improve security, fairness, and standards in the private rental sector. This was due to what had been seen as an increase in rogue landlords, unfortunately. The key drivers when the bill was first proposed were the government's concerns over no-fault evictions, so the Section 21 process, and the amount of insecurity this provided for tenants, i.e., your landlord may want their property back, but where does the tenant go from there? Also, substandard housing and unsafe conditions were of a massive concern, and the lack of rights of enforcement to local authorities and the likes. There was also a big desire to reduce discrimination. As you know, tenancy agreements allow for you to state that you do not wish to have people who receive benefits or indeed children. So they wish to eradicate that from agreements, to improve transparency between landlords and tenants, and reduce any exploitative practices such as rental bidding, etc. So where are we right now? As you can see, it's been going through Parliament for some time now. In respect of the legislative process at the moment, the bill has been progressed through Parliament and it is in the final report stage. So with the House of Lords to make the final decisions, and they're and then that will be published depending on the version that's finally agreed. So we are expecting the royal assent will be given in late 2025. So we're approaching that fastly. Most provisions are anticipated to be operational and implemented by 2025 or at least early 2026, which will obviously mean a lot of documentation reviews. So the key changes that are proposed and what we need to look out for as managing agents. So the first change that's provided for is the abolition of Section 21 notices, so the no-fault eviction process. So what we need to be looking out for as agents, so that we need to ensure that landlords know that they will no longer be able to rely on the current Section 21 process to evict tenants without a valid reason. They will need to use one of the possession grounds under the new law. Now, these are set out in quite some detail, so I haven't included these in the slides, but if you look at the bill in its current drafting, they are there for you. So there's also the move on from an AST, and that move is to a periodic tenancy. So fixed term assured tenancies will be removed entirely, and tenancies will automatically become periodic. So those that are currently fixed term will actually change over to periodic. There hasn't been any absolute detail on how this will happen, but that's what is planned. So the tenant gives 2 months' notice to leave under this process, and landlords must rely on legal possession grounds for eviction. Again, these are set out in some detail in the bill. So the change in relation to rent increases, these are going to be limited to once per year, and the landlord or you as their instructed agent must give a statutory Section 13 notice to do so. Any overly high increases can be challenged by the tenants via the first tier tribunal, which is going to probably open up a huge can of worms, particularly as at the moment there is no guidance on what will be seen as a fair increase or indeed overly high. So just continuing on there for other things to look out for. So the Decent Homes Standard and Conditions / safety regulations are going to be high on the agenda in the new legislation. So all properties that are privately rented must meet the Decent Homes Standard. That includes hazard repair timeframes, which is similar to AWAB's law, which has actually already been implemented in the social housing sector. It's going to carry over into the private rental sector. And these are going to give local authorities much stronger enforcement powers, including notices to stop letting the property or indeed quite severe fines. In respect of the private rental sector, they're going to introduce an ombudsman and a property portal. Now, all private landlords, whether they use an agent or not, will be required to register and join the new ombudsman scheme. The property portal is also likely going to require a registration. That will be for the landlords themselves and also for the properties that they are letting. So agents are going to likely have to be involved in helping their clients in compliance and registration, etc. It's also been mooted that there's a fee to join the property portal, but at this stage that hasn't been finalised. There's also going to be prohibitions on discrimination and unfair practices that have been noted prior to the bill going out in its first draft. So the government are quite keen that there will be no blanket bans for pets. So we cannot discriminate against tenants who are in receipt of benefits, as I've mentioned previously, or those who have children. There will be limits on rents demanded in advance. There'll be transparency of asking for rents. And there'll be a total prohibition on rental bidding wars. So that will be banished totally under the new bill. So what are the implications for you as agents and your landlord clients? There's going to be a lot of operational and administrative changes that will need to be dealt with. There'll be new processes for the notices themselves, the possession grounds, the rental increases. It's likely going to increase the amount of documentation and also put the burden on you of keeping correct records for longer periods and ensuring that everything is signed off and compliant with the new regulations. So how do you train your landlord clients and how do you train your teams internally on the competencies that are required? The bill makes it clear that there's going to be an increased scrutiny on agents' compliance and what their knowledge is of the system and regulations. It's potentially been mooted that the regulations will require a minimum qualification or standards that are going to be applied across the board for managing agents. And Parliament are currently still discussing the mandatory qualifications of property and managing agents. Now, I'm sure you'll have recently seen the recent hearing that has gone through and judgment in respect of Mazur and Stewart, which has basically stated that nobody who isn't qualified as a solicitor can sign proceedings or enter into proceedings or deal with live court cases. So that's something that you may also wish to consider. In respect of the risks of not complying with the current legislation once it's passed. I won't say current legislation, so the legislation as it's passed. There are going to be greater penalties. Those penalties may be against landlords, but they are being mooted to be against agents as well. There's likely to be a higher increase in tribunal rulings where tenants are pushing in respect of higher rents, not being fair, not being reasonable. The risks about safety, it's going to be absolutely obligatory that landlords ensure that the hazards and safety of their properties are at the utmost importance. The condition standards, they're going to be set Everybody's going to have to follow them. There's not going to be one rule for one rule for another, as it has been across local authorities. It's going to be a blanket across the UK. So in respect of your landlord clients, you need to make sure that you're advising them actively. Some landlords' goals are different. They may wish to have their property back. They may wish to recover rent arrears. We really need to know from the outset what their goal is with their property portfolio. So it may be that some of your documentation, terms and conditions for managing, etc., need rethinking. In respect of revenue business models, it's likely that there's going to be fewer eviction-driven turnovers. Hopefully there'll be better maintained properties, which will likely increase costs for landlords, but likewise could increase rents for the sector. And again, we're back to administrative burden. Now, you will all be undertaking inspections for your landlords. I have no doubt about that, but it's time now to look at what those compliance checks look like and perhaps get round and do those inspections now. So I've just put some pointers down here of what you should look at now to prepare for the bill coming into use. So it's suggested that you review all current tenancy agreements, identify where they rely on Section 21 or fixed term clauses that will soon become void. Discuss it with your landlord. Do they want to act on the current legislation, or are they happy for it to roll into the new regulations? Update any precedent tenant communications, such as your onboarding procedures. Look at the notices that you send out. Look at what you send out in respect of the rents that are being sought. Look at what due diligence is done in respect of what rents are being sought. It's possible that some of you'll need to look at some policies that you've already got in place for landlords, in particular in respect of pets and rental increases. We strongly suggest you look at those now. Please ensure that your landlords understand their obligations under the new possession grounds. It's going to be difficult, I think, for a landlord to appreciate that they cannot just get their property back like they used to be able to. We also need to ensure that we also need to make sure that they're getting ready to register for the Ombudsman and the property portal. Keep up to date with any increasing fees, or indeed any fees that need to be paid for joining these. It's likely that it's going to be much like the Welsh process at the moment. So we suggest that you go out and audit your properties now, look at safety compliance issues, compare them with what's being proposed, so you can remedy those hazards now, and any deficiencies can be dealt with rather than waiting for new regulations. And obviously non-compliance then will lead to higher penalties. We're suggesting that you set up dedicated internal compliance monitoring and record keeping. Make sure your staff are all trained and they know what's expected of them under the new legislation. Please plan for increased interaction with enforcement authorities and the tribunal. There could be a need for a designated person or a team that deals with such matters, but hopefully, if everything's been compliant, if everything's been looked at, if hazards have been remedied, there shouldn't be a need for such a purpose as a full team to deal with this for you, depending on the scale of your operation. We'd always suggest that you seek advice from a solicitor on the regulation, policies and compliance. And here at Forbes, we have teams that cover all sorts of these issues, such as the commercial team who can look at policies for you. So what are the outstanding issues and what are people still looking out for? So the exact details of the transition periods remain to be confirmed, i.e. when will the provisions come into force and what actually happens to existing tenancies versus new tenancies? Will they all be covered under the same new legislation? Will there be a period where they move over to the new legislation? We just don't know at the moment. So there's also a lack of clarity on how the decent home standards will be defined in the secondary legislation and what costs implications there will be for landlords and agents. So who deals with these, who makes a payment for rectification, etc. We're still lacking clarity on how the Ombudsman will operate alongside the existing redress schemes. Will the current redress schemes fall away, etc., or will there be overlapping responsibilities? There's a large concern at the moment in the legal world about the capacity of the local authorities, courts and tribunals to handle certain increased workloads, in particular regarding enforcement and the decent home standards. Also, I alluded to it earlier. How will rent increases be judged as above market? What is the evidential burden, and who does that fall upon to prove such an issue? I'm sure you may be aware in current tribunal matters there will be the use of experts, etc. But who will be those appointed experts in respect of the new legislation? We just don't know as yet. So what are the benefits and opportunities you can look out for as agents? So I've said it before, but firms that adapt early may gain competitive advantage. You'll be seen as highly compliant already, high quality, and a safe pair of hands and good to go. You're ready. You've already looked at your documentation. You've got everything in line. If you've looked at your documentation, you may be able to avoid or predict void periods, such as student lets, etc. And then you can monitor those more easily and see if you can move them to more stable tenancies. There's the opportunity to improve your reputation and trust with landlords and tenants alike, just by being fair and transparent, explaining to everybody what the new compliance regulations are. So regulation and compliance are going to be the highest thing on a landlord's radar now when instructing an agent. That's what you're there to do. You're there to provide a service to them and guide them through these processes. So it will be much like when we're instructors as a legal advisor. You are their trusted advisor, and they will be looking out for who are dealing with these compliance issues swiftly. So it could be possible that fewer adversarial situations if conditions and maintenance standards are upheld proactively, less complaints, less issues. If we're ensuring maintenance is of the highest standard as per the Decent Home Standard, there should be less complaints raised by tenants themselves. So to ensure compliance in policies and documents, again, I would recommend that you reach out at this early stage to legal advisors such as Forbes, and we can go through the documentation for you. So risks and challenges. There's bound to be an increased administrative cost and workload for you as agents and as landlords. Notices, compliance, record keeping, dealing with local authorities, all on behalf of landlord clients. Please make sure that you're reviewing your own charging structures with those landlord clients. So you can't charge renewal fees because the fixed term tenancies are going to be abolished. Instead, fee structures should be looked at and communicated with tenants and landlords alike to make sure that the landlords are aware of what they can and can't charge. There's a potential impact likely on cash flow, obviously, longer tenancies, lease ends, fewer fixed term renewals, and the fact that those renewal fees can't be charged. If disputes arise and if the matter proceeds to tribunals, it's going to be imperative that you've followed the procedures correctly. Any sorts of fines, etc., could be against both landlords and agents alike. So again, we would always recommend that you seek legal advice. If you have landlords who are resisting change, obviously this could create friction with them and complaints from your landlord clients who are not sure of what's going on, or they're not wanting to follow the new regulations. You have to be clear in your instructions to them how strictly these new regulations are going to be imposed. Be upfront, explain to them the investment required for the safety and condition of the properties. If improvements are needed, make them now. Make sure they're done correctly by approved contractors. Everything then, document it for your own safety as well as the landlord and the tenants themselves. Obviously, there's going to be a likely increase in legal costs. If regulations are not being followed, matters in the tribunal are not cheap to defend. So this is just a little timeline of suggested things to do. So within the next 3 months, look at all your ASTs out there. Look at your management fees with your landlords. Educate your landlords. Start updating templates that you send out to them, and also your internal templates. Update your checklists on what needs to happen when a new tenant comes in, and likewise when a tenant's leaving. Train your staff. There's so much information out there now. If you look around the landlord portals, etc., there's an awful lot of things that is out there to help estate agents and managing agents alike. Make sure that you're monitoring all regulatory guidance. They do come through as updates. You can get updates from the government website. I would suggest that you do that. So in the next 3 to 6 months, make sure you've looked at all your existing tenancies and see what grounds can or cannot be relied on about bringing them to an end, particularly if a landlord wants to reduce their portfolio. Make sure you've got a tracking system in place in relation to compliance, and carry out all property condition checks while you can. Make sure any hazards or any issues in condition are dealt with now, and then budget for changes. If works are needed, let the landlord know what likely costs of these are now at an early stage. Sorry. So after royal assent and the implementation of the Act, make sure that you shift to the required practices. Make sure that your landlords know that this has to happen. Make sure that you and your landlords are registered on the property portal, both personally and the property itself. Join the Ombudsman. If there's going to be a fee, make sure that fee is paid. Please ensure that your internal systems are in line with new legislation. As you know, when we're asking for witness evidence, etc., it's highly important when seeking possession of properties that we have a full record of what has or hasn't happened. Make sure new notices and new rent increase procedures are followed to the nth degree. There's not going to be a defence likely of ignorance in this instance. So I've just put together here a few points in respect of questions that we get asked a lot here at Forbes in the property litigation team. So a new digital private rental sector database is going to provide visibility on who landlords are and any historical banning orders they've received, so tenants can make more informed choices. So if anything does go wrong, it will be registered on that portal. The bill is also, as I've said, going to introduce the use of an ombudsman. This is seen to be offering a fair and impartial resolution service to settle disputes without the need for court involvement. However, there's no exact detail on how this is going to be manned, and indeed if that can run in line with the current redress schemes. The bill is looking to outlaw any discriminatory blanket bans on tenants with children or those on benefits, ensuring that everybody has a fair access to housing. Under the bill, landlords will have a few reasonable excuses for not accepting pets in their properties. These that are set out at the moment are if the property is unsuitable for pets, such as the size concerns or lack of any adequate outdoor space for the animal, that the property is actually a leasehold property and the freeholder has imposed restrictions that must be complied with. If there's issues in relation to pet ownership, as you know, there's registers, etc., for people who are banned from keeping animals, or indeed if the animal or their owner have caused any form of antisocial behaviour. That hasn't been defined fully as yet, but these are the things that are being looked at in respect of pet ownership. In respect of deposits, the deposit rules remain unchanged under the new system, so you can still take them in advance, but they again must be protected in the approved government schemes, and that information must be passed to the tenants. So in respect of agents and passing keys over, you have to pass the keys over if the agreement has been signed, even if the first month's rent hasn't been paid by the tenant. The new regulations require tenancy agreements to be signed before collecting rent. So this gives tenants legal rights to occupy the property, regardless of whether they've made that first payment of rent. So that's something to bear in mind, and please do share that with your landlords. So moving over to notices, and just a few answers here to some questions we get asked a lot. Will there be any transition period or a cut-off date for existing Section 21 notices? So the government is expected to provide a slightly longer transition period than a standard 2 months after the bill reaches royal assent and becomes law. But we don't know for definite how long that will be, or indeed when the assent will be. So on the commencement date, all ASTs will definitely convert straight over to assured periodic tenancies, meaning no new Section 21 notices can be served. Please bear that in mind and let your landlords know. If you're looking at the ASTs now, like we've suggested, it will be something to be discussing with them within the next few months, definitely. So what will happen to existing Section 21 notices that have already been served, or if possession proceedings are in court? Now, it's said at the moment that if a Section 21 notice has been served before the bill is enacted, landlords will have up to 2 months after the commencement date to apply to court, as long as the notice is still within 6-month validity, which is still in place at the moment, and we're all aware of that. Please bear in mind, as I've said, the recent the recent outcome in the Mazur matter on who can actually sign those possession claims now. In relation to Section 8 grounds, the government has provided a range of new and updated mandatory and discretionary eviction grounds for Section 8. Those are set out in quite some detail. They're quite lengthy. It has opened a few more doors for landlords, but again, we're not going to be given the security of the no-fault eviction, unfortunately. So if your landlord serves a notice to evict their tenant and they're selling the property and the sale falls through, how long must a landlord wait before reletting that property? There's set to be a restriction period of 16 months from the service of the notice before a property can be relet. Please let your landlords know that. I mean, it's likely that the property will go back on the market, but again, it's not been set in stone exactly what evidence there has to be that it is on the market, it is being sold, but please bear in mind that 16 months notice period. So rental increases, mandatory Section 13 notices there. When the bill becomes law, periodic tenancies are going to replace all fixed term tenancies. So put simply, this means that landlords will only be able to raise the rent through the Section 13 notice period, and they can only do this once a year. Previously, landlords only needed to give 1 month's notice of a rent increase under Section 13. However, under the new legislation, they must now provide 2 months' notice to those tenants. So again, something to be discussing with your landlord if they are looking to increase their rentals anytime in the near future. So while it was a whistle-stop tour, if you need any help whatsoever in preparation for the bill being implemented, we've got you covered here at Forbes with teams that we can go through your policies, with teams that can go through your tenancy agreements and draft notices, etc. Please just reach out to us. The bill is set to be far-reaching and bringing massive changes to the private rental sectors. Managing agents, you're at the forefront of ensuring that compliance and good practice is standard in the industry. Proactive preparation is essential to avoid disruption to you, your landlords. It's essential to avoid risks or reputational damage that you've worked so long to build. The reforms provide an opportunity to raise standards of properties available in the private rental sector and improve tenant satisfaction. This will hopefully build the trust in the sector again. Thank you so much for your time. My details are there. If you want to reach out at any point, just let me know. Thank you.